Supreme Court of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning, ladies and gentlemen, and welcome to this oral argument session of the Tennessee Supreme Court based upon a national docket. However, as we can all see, we are doing this as we have been for the past several months by video conferencing. We utilize the Zoom platform and are moving forward with that and have done so the past few months. We also welcome those of you that are viewing us on YouTube, as we have been live streaming these oral arguments for the past few sessions as well. We're happy to do that to provide access all across our state or all across our country to anyone who would like to see the oral arguments and the cases we have before us. Today, we have 4 cases on our docket that we will have interspersed throughout the day. And we will begin here shortly with our first case. I do want to say a special thank you to the lawyers for their participation in doing this by video conference. We certainly realize that it takes us out of our comfort zone because I haven't been used to doing everything in the courtroom, but perhaps that's a silver lining of the COVID-19 virus situation. We're learning we can do a lot of things that we didn't do before, but maybe even more efficient in many ways. We also realize that it's easy to speak over each other during the course of arguments in this format. We will make every effort to do as little of that as we do. We also generally try to identify ourselves when we begin to ask questions so that the lawyers can quickly zero in on which justice is actually asking the questions. So we remind both sides that each side will have 30 minutes for argument of its case. If the appellate wishes to reserve any time for rebuttal, please do so at the beginning of your argument. Other than that, Mr. Hibner, I think we're ready to begin our first case. Would you call our first case, please?
Re Neveah M.
All right. The appellant will go ahead.
Good morning. My name is Kelly Summers, and I represent the appellants, Christopher and Hope Gaines. The Gaines are the custodians of the minor child, Neveah, and they've had her in their care since June of 2015. I'd like to reserve 5 minutes of rebuttal and allocate 8 minutes of my time for the guardian ad litem, Mr. Miller.
All right.
Be focusing his time on the legislative intent for TCA 36-1113 G14. So there are 2 issues before the court today. The first is the split of the decisions of the in the Court of Appeals regarding the interpretation of the ground for termination in TCA 36-1113 G14. My client's position, as well as the amicus, the State of Tennessee Department of Children's Services, is that subsection G14 should be interpreted according to the plain language of the statute, as the Court of Appeals did in Re Neveah M. In order to terminate parental rights under this ground, the petitioner needs to prove that the parent failed to manifest an ability and a willingness to assume custody or financial responsibility of her child. Specifically, the parent must have manifested both an ability and a willingness to assume custody or financial responsibility. So if a parent only manifested either a willingness or an ability, but not both, then parental rights may be terminated under this ground. It's important to look at the statutory construction rules to better understand the interpretation of this statute. The most basic statutory construction is to ascertain and give effect to the legislative intent without unduly restricting or expanding the statute's coverage beyond its intended scope. The text of the statute is of utmost importance. A statute should be read naturally and reasonably with the presumption that the legislature says what it means and means what it says. Additionally, statutes were enacted at different times but pertain to the same subject, must be interpreted in light of each other since they have a common purpose. If the construction of one statute is questioned, then the court may be aided by considering the words and legislative intent by the language of another statute. So statutes relating to the same subject or having a common purpose are to be construed together. In construing statute, courts must presume that the legislature has knowledge of its prior enactments and knows the state of laws at the time it passes legislation. Courts should also seek to avoid placing one statute in conflict with another statute and resolve any possible conflicts between statutes in favor of each other as to provide a harmonious operation of law. In applying the statutory construction.
This is Justice Lee. Is this statute ambiguous in your view?
I don't believe it's ambiguous. I think that is the argument that Mr. Miller is going to address. And
so if it's not ambiguous, we don't need to get to legislative history, do we? Can we just take the plain language and consider what it means as written?
Right. And
where does legislative history factor in?
Well, I think it's always important to look to legislative history when there's a statute that it's being interpreted in two different ways by the Court of Appeals, and so legislative history is important to try to help resolve the conflict between the two.
Well, and this is Justice Bivens. Doesn't that point to lend a strong argument to the conclusion that perhaps this statute is not clear and unambiguous? That in fact, because we've got different panels of our intermediate courts of appeals going different ways based on the same language, wouldn't that seem to indicate perhaps there is some ambiguity in the statute?
I think that is a legitimate argument, and that there is a recent case in Re Braylon, I believe is the name, that addresses the statute as whether it's ambiguous, and comes to the conclusion that that because of the legislative intent that was garnered from listening to the committee meetings where Lisa Collins spoke, that they concluded that the statute was not ambiguous. And I would concur with that decision. I think that's an alternative to finding that this statute supports the conclusion that you should read the statute in its entirety. I believe that the court in Re Aiden S did not read the statute in its entirety when determining that "and" only applied to ability and willingness, as opposed to a parent having to manifest both of those, ability and willingness. Otherwise, you get to the ridiculous conclusion that a parent simply only has to say, "I'm willing to take custody of my child," and nothing else to defeat the ground. And I don't think that was the legislative intent that was put forth as far as this ground. It would not make any sense to just allow a parent to defeat a ground by simply making a statement of willingness. And
Ms. Summers, this is Justice Page. Are you saying your opponent's position is that a parent who has no financial ability to support the child and placing that child with that parent could cause a substantial risk of physical, emotional, psychological harm, that all that parent has to say, according to your opponent, is, "Well, I'm willing to do this," and under their interpretation of the statute, they should stop the parental termination? Yes,
sir. And I think that you don't have to look any further than the case of Allison P. It's a case out of the Eastern Section of the Court of Appeals to find that absurd outcome is possible. That court found that the mother's statement of her willingness to assume custody in several months in the future, she wasn't even talking about at that time. She was living in a trailer halfway house with several other women, and had no ability at that point in time to assume custody, but she's made a statement of her willingness to do so in the future, and that was enough to defeat the ground for termination. So I do think that the cases bear out that there are absurd conclusions when you follow the Aiden court.
Ms. Summers, this is Justice Clark. What role, if any, does this court's analysis in Re Bernard T play in this case? It analyzes almost identical language, but in another subsection of the statute.
Correct. I think that it's very important. I think as part of the rules of legislative of statutory construction that you shouldn't place two statutes at odds that are within the same, especially within the same section of the statute, but both dealing with grounds for termination. And the court in Re Bernard did find, this was a a Supreme Court case, I'm sorry, that upheld the ground where the father had said that he was willing to take his children, but that he wasn't financially able to do so. And that was enough to find that his rights should be terminated under that ground. And so if the court follows the line of thinking in Aiden S, then it's going to put that statute in conflict with subsection 9(4), dealing with putative fathers.
But Ms. Summers, this is Justice Bivens again. If we accept your interpretation of the statute, aren't we treading into a territory where a parent could lose their parental rights simply because of financial problems?
No, I don't think that that's. I think that it's.
Well, how do we prevent that?
How do we? I'm sorry, I didn't understand.
How do the courts prevent that from happening? From that being the ultimate effect of the construction of the statute that you're articulating?
Well, I think that parents have an obligation to be able to support their children and to provide for them. That's part of the grounds for termination under the abandonment statute. So I don't think that this ground changes anything as far as requiring them only to be financially responsible. There's lots of ways for a parent to be financially responsible. It doesn't always require having a lucrative job. They can access benefits that through their state to help take care of their children.
Summers, this is Justice Kirby. Doesn't the provision at issue in this case also require the petitioner to prove, in addition to inability, it also requires the petitioner to prove a risk of substantial harm to the physical or psychological welfare of the child? Isn't that some protection against removal of a child and termination of parental rights simply on the basis of financial challenges?
Yes, I think that is correct. That's the second prong of the statute, and I do think that that's safeguard. And I think there is a case that discussed that, and I can't recall.
In Ray Braylon mentions.
Okay, yes, that mentions about the safeguard as far as not just terminating for financial issues, because of the second prong of the statute that ensures that doesn't happen.
Ms. Summers, this is Justice Lee. Justice Clark asked you about Bernard T, which does seem to support your position, but Bernard T, the issue there was reasonable efforts by the department. And there was really no analysis of the language of this statute in terms of being willing and able. The court just made a conclusory statement here that, there was clear and convincing evidence that he did not have the ability, that this parent did not have the ability to assume legal and physical custody. But there was no analysis given to that particular language of the statute as we are doing here. Instead, the focus is on reasonable grounds. So while the result may be supportive, the analysis of that case really doesn't have any bearing on this case, does it?
Well, I think it's important to go back to the construction of statutes and placing one statute in conflict with another, and I think that's the risk that we take if the Aiden S line of cases is followed. I think that the last issue that I would address is the second part of what the court has agreed to hear is whether, if the court finds that the Aiden S line of cases should be followed, whether this case should be remanded to the trial court to make additional findings of facts and conclusions of law as to the issue of ability and willingness to assume legal or financial responsibility for the child, assume custody and financial responsibility. In the case of Zaley W., I think that court supported where there was not sufficient findings of facts on this issue, that it should be remanded to the trial court to make additional findings. I believe that there's sufficient evidence in the record to support the trial court making findings on both the issue of willingness and ability to further satisfy the more stringent requirements of the Aiden S cases. And so I would ask that it be remanded if and only if the Aiden S line of cases is followed. I think that's all I have at this point. So if I could turn my time over to Mr. Miller.
All right, Mr. Miller.
May it please the court, I am Thomas Miller, the child's guardian ad litem. I think we all agree that this case is before you because of the split of authority about the proper interpretation of G14, whether you have to show both a willingness and ability to assume custody or financial responsibility, or either an ability or willingness. I propose an alternative basis for finding that the Amen court reached the correct interpretation. And in doing so, I rely heavily on the analysis in the Braylon S decision, which was rendered on July 20th of this year. I submit the following: that the disputed language of 36.113 G14 is ambiguous, that the ambiguity should be resolved by considering the legislative intent, and that it was the intent of the legislature to provide a ground for termination if the petitioner proves either inability or unwillingness under the statute. And I will add here that there is that safeguard about the second. We've been talking about the first prong of the statute. The second prong of the statute provides the safeguard that petitioner must also show a substantial risk of harm to the child. A statute is ambiguous when the parties derive different interpretations from the statute and when both interpretations are unreasonable. And it's hard for me to see when you've got this clearly distinct line of cases from different panels of the Court of Appeals finding that make fundamentally inconsistent interpretations of the statute. I mean, I don't know that they can be reconciled. And when neither of those interpretations is unreasonable, then the only reasonable conclusion I submit is that the statute is ambiguous. Over 100 years ago, this court stated that a statute is ambiguous when it is fairly susceptible to two or more interpretations. That was the Atlantic Coast Railroad Company decision in 1908. And that different panels of the Court of Appeals have, over time, interpreted the first prong in fundamentally different ways is, I submit, a very persuasive indicator of the statute's ambiguity. Once you find that the statute is ambiguous, then you look to other reliable guides to determine the legislature's intent and purpose. And in this case, the legislature's intent could not be stated more clearly in the legislative history of the statute. The Breland Court thoroughly reviewed the legislative hearings and found, in the court's words, Attorney Lisa Collins' testimony to be enlightening. She testified as to the purpose of the statute. She said that its purpose of this section was to provide a ground for termination when a parent had shown either long-term inability or long-term unwillingness to provide for a child, and that such conduct leads to harm to the child. There were other legislative hearings after her testimony. Her testimony was never questioned or contradicted. In the case, the specific case that's before the court, I submit that the trial court correctly found that the mother failed to manifest an ability to personally assume legal and physical custody of the child, and that this finding satisfies the first prong of the statute when it is interpreted in a way that comports with the intent of the legislature. For these reasons, I ask this court to reverse the decision of the Court of Appeals.
Thank you, Mr. Miller.
Yes, sir.
Mr. Mills.
Okay, I was having to get my mute button off there. My name is Steve Mills. I represent the mother in this case, Miss Katharina Moore. My argument is fairly simple. It's my position that the legislature knew what it meant when it said and. It knew the difference between and or, and has already been argued several times. I think everyone's agreeable that that when a statute is not ambiguous, then it should be interpreted as it's actually written. I don't believe that it's ambiguous. These are not two new words. And or has been around forever. I think the legislature understood the difference. If you look at the history of various cases, it's not the first time and or has arisen as an issue.
Mr. Mills, this is Justice Clark. If that is your straightforward position, and it's easy to understand, but does it in fact not lead to the possibility and probability of absurd results, that all a parent ever has to do is say, I'm willing, and there can never be a termination no matter what the rest of the circumstances are?
No, Your Honor, I don't think that would lead to, I mean, say it would never lead to an absurd result. Impossible for me to say. However, I think as a rule, it would not. I think that as in this case, she took steps to show that she had a willingness to assume custody. She didn't just merely say that I want custody, she actually took the steps to show that willingness. At the time that this petition was filed, she had filed a pro se motion in juvenile court asking to be reunified with her child. She had taken steps to get herself into rehab. She had just had another child just recently before that she was taking care of.
Well,
So,
actually,
I'm sorry.
Mr. Mills, this is Justice Kirby. I don't mean to interrupt you. We're aware of the facts in this case, but obviously we have to interpret the statute envisioning other circumstances, and also in a way that's consonant with the almost identical language in the other provision that several of the other justices have referred to that was discussed in Re Bernard T. And as to subsection A9, in the language that was at issue in Bernard T, it actually has led to absurd results, hasn't it? In a case, when I was on the Court of Appeals, there's a case that was issued before Bernard T involving that same provision, in which the father, and it's called In Re State DCS versus Williams. In that case, the father was incarcerated and fought having his parental rights terminated. And the panel, the majority on the panel, interpreted that provision in the same way that you are proposing, and held that the ground for termination as to that father was not established because he had said, I'm willing. Mind you, he was incarcerated. I ended up dissenting from that case and pointing out that it's not consonant. I mean, it's exactly the situation Justice Page asked about earlier, because in that circumstance, literally all he did was say, but I'm willing and I would love to take custody of this child. So to Justice Clark's point, and we traced the whole history of the parental termination statutes in the Kalia case. And the statutes are clearly oriented to put a premium on permanency for the child. But in that circumstance, so long as the parent says, but I would love to parent that child, then the child languishes in foster care and cannot achieve permanency. Isn't that exactly the absurd result Justice Clark asked about and that Justice Page asked about?
Well, I'm reluctant to call any judge or either trial court or appellate court making bad decisions, accuse them of making bad decisions. Bad decisions happen. I understand that. Sometimes there may be some absurd rulings. But again, I think that gets back to analyzing the facts of each case. And in that particular case, and again, I've read it, but I do not claim to be the authority on that particular case. However, the fact that the man was incarcerated, he may have had the willingness, but I think as I don't have, it's hard for me to manipulate my documents here in the setup that I am. However, the fact that someone may be incarcerated and they may say, I want custody, I think there's more to, rather than trying to split the difference between and or, I think you would be better served to better define what willingness means.
This is Justice Clark again, but continuing on that line of analysis, because that's really a mental state, it's going to be harder to prove. What happens though in the more typical cases, somebody's not incarcerated, but their circumstances are not good. They say, I'm willing and I desire to take on this responsibility, but the entire rest of the proof is they are not able. And yet no matter how strong the proof is that they are not able, because they say they're willing, there still cannot be a termination.
Well, I guess that could happen, but again, if we get back to what the statute itself says, let the legislature go back in and fix their mistake. If it truly is a mistake, let the legislature fix it. And
let me hand you the converse situation, Mr. Mills. What if the parent has the ability, plenty of money, posh house, all that, but says, I don't really want to parent this child, unwilling to do so. Under your interpretation, that child languishes in foster care. There's no termination of parental rights, even with a parent who says, I don't want to parent this child. I have the ability, don't want to do it. It's not, I understand what you're saying, that bad facts make bad law, that sort of thing. But in that situation, the courts are constrained under your interpretation. The courts don't have the ability to tailor the results according to the facts. We are bound by the statute.
Well, in your theory there, or your hypothetical, if I was the one, the plaintiff on that case, rather than relying on this statute, I would go after the abandonment, because clearly if they had the financial resources to support this child and they just weren't doing it, then I'd go after the abandonment statute, not this statute. I mean, there's a long list. There is a long list of other grounds available, such as if a person is incarcerated, there's statutes that apply in those situations. So I understand what the intent of this statute was to give some additional ammunition to that's wrong. I'm sorry. That's the wrong phrase. Excuse that.
Mr. Mills, excuse me, this is Justice Lee, but when would the statute ever apply if a parent responds to the petition to terminate and says, I oppose, I'm willing? I mean, it would never apply.
It may not. It may not ever apply. But
you think the legislature intended to pass a statute that would never apply if a parent answers the petition and opposes termination? It doesn't make any sense to me.
Well, I mean, it's no different than taking a default judgment when somebody doesn't answer. I mean, if there's plenty of other grounds to terminate parental rights other than this particular statute. So there may be situations where this statute doesn't apply. I handle, my practice has changed over the years, but I still 2 or 3 times a year, I'll accept court appointments for these type of cases. And most of the time, these cases end, the parents are not trying to defend these cases. So I think in most situations, it's rare for this statute not to apply, because in most of the time in parental rights cases, the parents don't truly defend it. I don't know what the percentages are, but it happens to me all the time where a parent will come in, they will say, I want to defend this case, and then I never hear from them again.
So mainly it's just going to apply in a default judgment situation.
It's in probably that's the ultimate effect of it. I do believe so. Yes, Your Honor.
Well, it is troubling that the legislative history talks about being ability or willingness, yet the legislature adopted ability and willingness. So there does seem to be some discord between what the legislative history indicates the purpose was versus how it was eventually phrased. And that may be what we're dealing with here. Justice Page, sorry.
I was about to get on the same topic. Mr. Mills, if we decide that this statute is ambiguous, do you agree that the legislative history is against your position? Will you concede that?
I will concede that. That's probably true.
Well, I guess that brings me to my next question. There's all sorts of jurisprudence that says if you have two reasonable interpretations of a statute, then that clearly makes it ambiguous. So I guess your argument has to be that it's clear and unambiguous as written, correct?
That is correct. And it's my position that I don't see how it could be any more clear than what it is. Very easy to read.
Mr. Mills, this is Justice Bivens again, going back to the Bernard T case for a moment, if we can. How would you suggest that if this court were to adopt your interpretation of G14 here, it certainly seems to be a different interpretation than the Bernard T court gave G9. How would you propose that we reconcile concluding differently as to almost identical language?
I don't know. I'm not that high on the legal chain there to make that decision off the top of my head. I don't know. I don't know how you would reconcile it. I guess it's two different statutes. They should be standalone. I don't know how to answer it, Your Honor.
Well, it might be what Justice Lee pointed out, that there was no real analysis of the issue in Bernard T. It was not really an issue presented in that case. The court reached a conclusion, but it was almost an assumption as to how the provision would be interpreted. There, did that help out?
Yes, Your Honor, thank you. I appreciate that assist.
Do you have further argument, Mr. Mills?
Well, the last part of my argument would be if the court does reverse the appellate court, send this case back to the trial court. I mean, I don't know that further hearing is necessary. The court's heard all the proof. This case has been pending since 2016. I don't know that there's anything else to add to it. If I don't know that it needs to be retried again. So if the court does remand it back for specific findings as opposed to a new trial.
So would you, this is Justice Bivens again, so would you agree then that even if we adopt your interpretation, the proper thing to do at that point would be to remand the case to the trial court for the trial court to make findings on the willfulness issue?
No,
this issue.
No, Your Honor, I'm not saying that at all. The only reason I'm addressing that is because that's what Ms. Summers has asked the court to do. I think this case has been pending long enough. They had every opportunity to present their case. They had every opportunity to make their arguments to the trial court. Ms. Summers is the one that drafted this order. So I think that, I mean, how many bites of the apple do they keep getting? And I think that's what it comes down to. We're over 4 years into this case. So it's my position that the case doesn't need to be remanded. But of course, I believe that the Court of Appeals should be upheld. But I'm not arguing at all that it needs to go back to the trial court. I think it needs to be dismissed outright. Go back to juvenile court. This case originally started before the termination and adoption. It started in juvenile court, and it had been in juvenile court for, I think, 2 years. Then it sped up to, and then the adoption has been in adoption court and Court of Appeals since for the last 4 years. This is a 6-year-old case. I think it needs to end.
Well, the trial court here made a finding of willingness and ability. So that factual finding has been made. So if we do agree with Ms. Summers' position, what would there be for the trial court to make additional findings on?
Nothing. That's what I don't think
Yeah.
that if you agree with her arguments, I don't think there's any need to go back to trial court. But my position is I think the whole case needs to be dismissed outright.
Right.
This is Justice Clark, and just to clarify, under the outcome that you are suggesting, what is the effect on the child? Does the child remain in state custody?
I think that the child is not in state custody at this point in time. I think the child has been in the Gaines' custody, I believe, since March of 2017. Mm-hmm. So the child has not been in foster care now for over nearly 3.5 years. So I think the child would remain in the same position. And I believe that if the case went back to juvenile court, my client would have to prove a material change of circumstances. So I think that would, unless the Gaines have made some major changes to their lifestyle since the time of this trial, I would find it hard to believe that she would prevail on a change of custody in the juvenile court.
But they would not at that point be eligible to seek adoption. Is that correct?
Yeah, I think if they meet the new, if at that point, if circumstances have changed,
yeah,
I think that they could immediately refile their adoption.
But a whole new lawsuit.
Yeah. A whole new lawsuit, yes.
All right. Anything else, Mr. Mills?
No, Your Honor. Thank you very much for entertaining my thoughts.
All right. Thank you, sir. Ms. Summers, for your rebuttal.
Thank you, Your Honor. I wanted to address the Bernard T. issue again about how you reconcile that with these cases, and if you follow the Aiden S. Line of cases, and I think you have to go back to the principles of statutory construction that when you have a statute that is relating to the same subject or having a common purpose, they're to be construed together. And this most certainly fits that scenario because they are both within the subsection of the statute that deals with the different grounds for termination of parental rights. So they couldn't be any more having a common purpose than that. And so based upon those construction principles, I think that the only way to resolve it is to follow the line of cases in Amaya S. And I would also address the absurd results that come about from following the Aiden S. line of cases. I cited one case earlier, and Justice Kirby cited one that she was involved in, and I think that that the cases that follow Aiden S. are all in line with simply just allowing a parent to state their willingness to assume custody or financial responsibility as a way to defeat the ground, and that which is in essence leads to no real way to overcome that burden. I think that the statute needs to be read in its entirety. And I don't think that the Aiden S. court did that. I think that they did not consider a parent's ability to manifest by act or omission. And those words are very important to the statute because they have to manifest those things in order to, I think it's both things. So it's read in the conjunctive. It's It's not read as or, it's read as a parent has to manifest both of those things by some act or omission. And additionally, I don't think that the ADNS courts have required any kind of showing of what willingness is. They just let it have mere words have been enough to defeat the ground without any kind of acts or omissions of acts on their part to support it. So that's all I have.
Thank you very much. All right, council, once again, we very much appreciate your participation in this format. This is our way of moving forward with our dockets in these days and to keep our justice system going. So thank you very much. We appreciate you being with us. We appreciate those of you that have watched on YouTube. We will stand in recess until our next case, which will begin at 10:30 Central Time. Thank you.
Thank you.
This honorable court is now in recess until 10:30 a.m.